Okay, so our last speaker now is Mairead Enright. Mairead is a lecturer in law at the University of Kent, and she blogs at humanrights.ie.
Hi, thank you very much to Alva and Sinead for giving me an excuse to come home for such an important day. For those of you who are also British affiliated, in case you haven't heard, Jeremy Corbyn is the new leader of the and that is significant because actually Corbyn has said that in the event that they don't have him assassinated and he becomes Prime Minister, that he's aware that Northern Ireland exists and he has spoken about extending the 67 Act to Northern Ireland. So there you go. So last year when I spoke at the first of these conferences, it was in the immediate aftermath of the Y case. And I was talking about the sort of current and ongoing effects of the existing law, the Constitution and the PLDPA. But I want to talk a little bit today about a sort of a dystopic future in which we do legislate after repeal of the Eighth Amendment. So the working title of the paper that I gave Alva was What Women Don't Need. And so assuming that we repeal the Eighth Amendment and assuming that legislation comes with that repeal hand in hand, what sorts of things might we want to be preparing to resist, let's say. And I do think that feminist transformative abortion legislation is possible. I do think that you could have legislation as an interim kind of stopgap on the way to light touch regulation or almost no regulation at all. And I think that the processes of public deliberation that could happen around building that kind of legislation could be politically important. But I'm not going to talk about all of that. I'm going to talk instead about Enda Kenny. So I'm going to talk about the kind of law that Irish women do not need, do not want, and yet may well get. So particularly since the Savita Halappanavar case, you've seen figures within Fine Gael and also within, of course, their government partners, the Labour Party, making kind of vague suggestions about what sorts of grounds they would permit women to have abortions under. And these statements usually begin with the phrase, I'm pro-life but, or I don't agree with abortion on demand, which means lots of different things, I would imagine, but. So what I want to do is I want to provide you with a spotter's guide, a connoisseur's guide, or an analysis of the legal imaginary which is underpinning what Fine Gael and Labour will describe to us as a middle ground or a moderate solution. And that's a misnomer because the kinds of stuff that they're talking about is not the middle ground in a European context and is certainly not the middle ground in an international context. It's a re-performance of the usual Irish exceptionalism, where we assume that our moral commitment to abortion law is so peculiar and so unique that our law must also be distinctive, must have nothing in common with the rest of the world. So how will we end up with this law we don't need and don't want? And one way in which we will is just, Catholic patriarchal ideology, light. So there is a tremendous sense still, as marriage equality referendum taught us, there is still in government a tremendous sense of obligation to compromise with what are political and religious fringe elements. The other thing is that there is still a willingness in political circles to describe themselves as part of an I'm pro-life but mainstream. So you will see a lot of discussion about, it's a lot of fetal-centric discussion. But what's always more interesting in terms of discourse analysis, particularly around law, is the sort of neutral common sense justifications. So what the Taoiseach spoke about yesterday was not babies or holiness. What the Taoiseach spoke about yesterday was uncertainty. It would be irresponsible of me to even talk about a referendum now because God only knows what's coming next. Right? So his argument is he needs to decide what will fill the gap, but he has no intention of beginning a process of consultation or law reform that would teach us how the gap might be filled. And it's a discourse of reassurance and it's a discourse of responsibility. And he says, what we must have, and this is so familiar from the PLDPA debates, what we must have is certainty. What we must be protected from is the spectre of abortion on demand. What we must be protected from is women's demands. So aside even from the profound distrust of women, which is implicit in that statement, although it is not overtly named, and aside from the fact to recognise that the current law is dangerous and the current law is uncertain, that statement is also legally inaccurate. If we repeal the Eighth Amendment, it does not create a void in the formal law. The PLDPA remains in force until there is litigation and until it is challenged. So the law remains as shit as it ever was. That's what happens in the immediate aftermath. And the other thing, of course, is just as an aside, that discourse of the, only death follows if we repeal the Eighth Amendment, is that there's no positive discussion of what the Constitution would look like if you took the Eighth Amendment out. Because if you take that trump of the Eighth Amendment out, we get to remember that women have rights and that they are written down in the Constitution. In the case isn't in the Constitution, there's a strong bundle of women's rights. I would say confidently that you could have an Irish Morgan Thaler if the Eighth Amendment weren't there. I think that's very, very clear, because what do we have? A liberal constitution with the odd bit of Catholicism lurking around the edges. The Eighth Amendment is the strongest bit. And so nobody is drawing attention in government to the kind of stuff that Anne was saying earlier, that there is huge potential for us to sit back and make a positive decision, to learn from all the other jurisdictions who have been regulating and engaging with abortion care successfully in the 31 years since the amendment was passed. So, my spotter's guide. What should you be looking out for? My colleagues told me 3 things. I have 3 things. The first thing you should look for is the retreat to the familiar. So they tell us the law will be terribly, terribly uncertain. So what should we do? We go back to what we know. And if you look at, and I have to name the Labour Party for this because unfortunately they're the only party who said at their most recent conference what grounds they would accept abortion on, what grounds they would permit us to have abortion under. But they've retreated to the familiar. So they're going to propose something which looks very close to Eighth Amendment Light or PLDPA Plus, in which case what's the point in having repeal at all? So one of the things, and I'm taking this from their own document which they published at conference, is that they say that women would be permitted to have abortions in Ireland, according to them, if they could demonstrate in early pregnancy a real and substantial risk to health. Now, not only is that total nonsense, but you know that phrase, real and substantial risk, because where does it come from? It comes from the X case and it's part of the PLDPA. And we know it doesn't work. And unless you're a total lunatic, why on earth would you want to keep that language after repeal? How is it a coherent legal approach? But there are also indirect spectres of the Eighth Amendment. All of this fetal-centric language, talk about viability, talk about time limits. There were attempts in the PLDPA to put in a fetal pain provision. And there is also the residue of the Eighth Amendment in the assumption that the PLDPA works and that what we should do is simply extend the PLDPA and retain a gatekeeping approach to women's healthcare, so that the point is that women are accountable for their decision making. The only reason you would want women to constantly account for their decision making is if you assume that the fetus must be protected. That's the underpinning motivation. There's also, and this is also a residue of the Eighth Amendment, this insistence on exceptionalism. So hiving off abortion from all of the questions of maternity and sexual health care, assuming that grounds is the way to go and that most women should continue to have to travel or to DIY, assuming that grounds should provide only for the care of deserving women in really, really terrible circumstances. Residual criminalisation. I think whatever legislation is proposed will retain some kind of criminal offence, probably of doctors. Right? None of that stuff can actually be constitutionally justified easily without the Eighth Amendment. Because again, once you take the Eighth Amendment away, women have all of these other rights, and any state interference with your constitutional rights must be demonstrably proportionate, and the burden of proof is on your side. Right? So none of this stuff should exist without the Eighth, and the Eighth is kind of zombieing, sleepwalking into their proposals already. The second thing you should look for is very restrictive language masquerading as providing certainty. So when we had some discussion about fetal abnormality and termination for medical reasons, some TDs genuinely said that they would legislate for fetal abnormality in circumstances where there was zero prospect of survival within the pregnancy. That is medically meaningless. And it sounds terribly certain because it's all or nothing, black or white, 100% or 0%. But it makes absolutely no sense. And the third thing you should look for is legal formalism, which is that's the kind of phrase we use where people are focused and fetishizing the text of the law and the process of writing the law and don't really think about what it will look like in practice. So you write the law, you agonize over it, and then the law is. And nobody talks about the fact, and this has happened with the Eighth Amendment and it will happen with bad legislation too, that the law lives in its administration, its application, its interpretation, and that most of that stuff happens not in the Supreme Court but in day-to-day medical practice. And there's a complete refusal to do 2 things. First of all, interrogate, and this isn't a mea culpa, but interrogate our own legal culture. And I include in this practice, judicial culture, and legal education, which is technocratic, litigation-focused rather than practice-focused, incredibly defensive. There is this ridiculous kind of homage which is constantly being paid to the Attorney General. The Attorney General simply says, and then there are no other possible conflicting interpretations. And there is also a failure to interrogate Irish medical practice. Now, of course, I'm not including Doctors for Choice in this, but if you read the Protection of Life During Pregnancy Act debates, you see two things going on. First of all, there's the discourse of doctors are afraid of the law, and good doctors obey the law even if their patients suffer. We saw that in particular in the PP and HSE case, where doctor after doctor came in and said, we thought we had to keep this woman under somatic care, we thought we had to treat her in this undignified way because the law says. Now, any medical ethics, I cannot think of a perspective within medical ethics that says that was ethical behaviour. At the same time, if you look at the PLDPA debates, you see the valorisation of that blind obedience by elite doctors, and at the same time you see a demonisation of other doctors who must be regulated in case they try to get around the law. So our notion of the relation between law and conscience in medical practice is very stunted, and that's precisely why Doctors for Choice are such an important voice. The other thing is that there's no proper research or consultation. A number of hand-selected elite voices trotting into an Oireachtas committee is not going to ground good law. And the last thing I'm going to say to you, some of you know, and we have to confess to this, that a number of us wrote a bill for the Labour Party, which they subsequently rejected. But in the course of writing that bill, and if Fiona could bring it up so you can see it if you want to read it, and I'll talk about it for a second, but the last 2 pages of that we called key questions for further research, because we had again and again a sense that there wasn't openness about the lived reality of maternity practice in particular, and that we were being asked to regulate something that actually we knew very, very little about, and that even the doctors we were consulting knew very, very little about. So there would be a proposal to legislate for what is effectively a brand new kind of healthcare service, and we wouldn't really have known what we were doing. So the last thing I'm going to say after the Spotter's Guide, as well as come to the Lawyers for Choice workshop, it's going to be great, is if any of you are interested, again, in that kind of preparing to build critiques of whatever is going to be trotted out as the middle ground, that bill we wrote, which we've published open access, and the link is there and the page is there, we're not shopping that as a model piece of legislation at all. It's not what we want. We're all free, safe, legal people. But we were asked to draft a middle ground. If you want to know what the middle ground, minimally, barely compliant with international human rights law, not completely disgusting, if you want to know what it looks like, read it and compare it with whatever is trotted out in the next year. That's what the middle ground looks like. The other thing is, Enda Kenny says, sure, who knows, how would we even regulate for the 8th Amendment? There, we did it for free like Egypt. It's there. It's there and it's done. And if you read it closely, you'll see there are some serious feminist touches in there actually. There are some serious, like we sleep ourselves to some extent. There are things cropping up. And it shows as well that you can research, you can learn from other jurisdictions, you can be open to creativity. The repeal of the 8th is a moment of huge potential for changing how we treat pregnant women in Ireland, and we must absolutely resist this discourse of damaging, dangerous uncertainty. Yeah.